subject to cogent explanations being given, I find some of the language gratuitous and at times both gratuitous and sensationalist. Let us look at paragraph 9.1 of the supplementary affidavit at page 54. There, Mr. Carrim says, I'm reading the last 4 lines, part of the 4th, paragraph 9.1, I said, yes. And quote, it would be concerning in the extreme if it were willing, that is the commission, to gamble with my life or my family's life to see whether the commission's, underline this, kill rate would result in a, again underline, hat trick, close quote. I read this to mean that the commission has killed, underline the commission, has killed 2 people, and that Mr. Carrim will be the 3rd person it kills if the commission does not grant his application. That is how I read what I've just quoted. Now, Mr. Premier, what evidence does Mr. Carrim have that the commission has killed 2 people?
Chair, may I say that I hear what the commission says, and that's not how, with all due respect, I interpret that sentence, because before Chair started reading from, it would be concerning in the extreme. The sentence from about 5 lines from the bottom starts with, the commission has already experienced 2 such incidences. So with all due respect, when it's spoken about the commissions, and I say 2 such incidences, taking the correction that Commissioner Khumalo has made already, I'm just reading out what's there. So how I read it is not that the commission killed anybody, but that the commission has experienced, in Mr. Carrim's version, subject to the correction, that 2 witnesses that came before it were killed, and that he's saying that the commission's kill rate, in the sense of the number of witnesses that they've experienced having been killed, would result in a hat trick, and that he doesn't want to wait and see that happening. But that said, I take the admonition in the way that it is presented, and all I can do is apologize to the commission if that indeed caused the offences both being gratuitous and sensationalist.
Thank you for...
of that public knowledge is that, well, an in-camera hearing is going to be pointless because everybody knows. But the truth of the matter is that if the in-camera relief is granted, then everybody will not know. Yes, they would have known what the arrangement was for Mr. Carrim to give testimony in an open session was, but they won't know what actually occurred thereafter if he doesn't give testimony in the way, in an alternative way, if the in-camera application is granted. So, with all due respect, the Commission's position that this has already been in the public eye is the very reason that we come to the Commission, because you will know we say that these threats have started emerging even before he's given the evidence. So it means that the people who are threatening my client don't know what he's going to say. But they are so aggrieved potentially by whatever it is he's going to say, that they're already making the initiative to threaten him, his family, his businesses, and his employees, as well as his economic interests, in the way that it does. The second thing that the Commission says is that, and it's a line of argument that is rooted in open justice principles, and indeed in the morning, I think it was potentially the Chair and Commissioner Baloy who put it to me when they said, I thought, or used words to the effect that I thought he would want to come and give this evidence in open so that everybody knows what's going on. But with all due respect, that argument again makes the case that we are applying for, and that is that this publicity, without the threateners even knowing what it is he has to say, are already threatening him. If he comes here, it's almost like waving, and that is not made subject to an in-camera ruling. It would almost be like waving a red flag at a bull and waiting to see whether or not the bull charges and gores you, and effectively to take your life into your own hands. And the reason I say that, and mindful of what the chair has already said regarding those particular paragraphs, fictitious, these are non-credible, are made up. They seem to accept, at least at the surface level, that these threats are real. And so the question then becomes for the Commission, bearing in mind, and the Commission and the Commissioners, bearing in mind that you have an applicant in front of you who says, I am scared, I am fearful. Does the Commission and the Commissioners turn a blind eye to that in circumstances where no one has suggested that those threats aren't real, aren't credible, aren't serious, and don't deserve to be taken as seriously? So that's point number one about why we're here. We're here because of the fact of the threat, and any opposition mounted on the content of the main witness statement, I would submit, is firstly misplaced, but secondly, to the extent it's not misplaced, it's but one factor in the basket of factors under your consideration. The second topic I want to talk to is the question put to me by Commissioner Khumalo. Commissioner Khumalo, you took me to the Schedule A, and you had indicated that the schedule was problematic because it excluded certain people and, was perhaps too restrictive in terms of the people that it did include. And you mentioned particular individuals like the head of the security, the investigation team, the researchers, and all these categories of people. I'm willing to accept that this might be too constrained, and the reason I can readily accept that is because we simply don't know who the relevant people are in the operation of the Commission behind the scenes. Likewise, for example, in trying to get the application in front of you, we don't know how long it took when the Commission received it to put it in front of the Commissioners, whether it was placed in front of you before the 25th of February, whether the correspondence bundle, like we asked to be placed in front of you, was placed in front of you. We don't know all of these things. And the reason I highlight that...
They're in the website, Mr. Freeman.
I beg your pardon?
They are in the Commission's website.
Please continue, Mr. President.
Be that as it may, it can be on the Commission's website, it can be stapled outside the Commission's premises. The point of the matter that I'm making, Commissioner Khumalo, is that parties often ask courts for relief all the time based on what they understand the position to be. Sometimes a court will say to them, as you will well know, yes, you've made out a case, but this operative part of your relief is a bit too narrow or a bit too broad, and we need to include these people and we don't need to include those people, or whatever the case is. So, with all due respect, if it's a question of the schedule, we can amend the schedule. Or if it's a question of the Commission making a directive regarding who should be included and who shouldn't be included if the Commission is with me, then that satisfies the issue with all due respect. Because like I said in the debate in the morning, and I think it was with the chair, is that these requests have always been subject to the chair making the appropriate ruling, either accepting and granting the application, or dismissing the application, or granting it but subjecting it to different grounds on the relief, or anything of that kind. So I think, with all due respect, it's a little bit difficult for me to answer the way in which the question was put at me in circumstances where it's being positioned potentially that Mr. Carrim is dictating these things. It's Mr. Carrim saying to the Commission, I'm asking you for these things based on what I know at the time that I know it, and I lay myself in the Commission's hands as to make the ultimate determination. So if the accuracy of the schedule is incorrect, we wear that. And we wear that not because we want to keep some people out or some people, we simply don't know. And that's why we come to the Commission and ask for the relief that we do. May I go on to my third topic? And I think, Chair, I'll be done with my protected time relatively soon. May I just take an instruction? Yes, and I'm just being pointed out that the particular paragraphs that Commissioner Khumalo had difficulty with was 3 and 4. I think what I've just addressed is the difficulty with paragraph 4. Regarding the difficulty with paragraph 3, I just would point out that it's not the main statement that was subject to the in-camera, it's the in connection therewith defined as being in the in-camera application. And I mean, even if the drafting is not clear enough to make that clear, let me make this clear now on the record. That must obviously be the case, because if the in-camera application that we're arguing now is unsuccessful, then the normal rules apply. But if the in-camera application that we are arguing now is successful, that would be subject to whatever the Commission and the Chair ultimately grants as the relief. And again, I understand that the concern against me might be what it is. I don't think that the idea has ever been that the main statement must be kept away from the relevant Commission staff. It must be kept away from it being an open publication, or as effective as an open publication, content in camera. And in regard to the Brown-Mokhotsi example that Commissioner Khumalo raised, apart from saying that I don't know whether Mr. Mokhotsi applied for an in-camera hearing or an in-camera hearing and how that would impact fair trial rights, like I said in the morning, part of the Commission's imposition of an in-camera regime would make accommodations, as it must, for these kinds of issues to be ironed out. So that, like we know, for example, in high court proceedings and in all court proceedings, where there is a confidential affidavit filed, sometimes what the court says is it seals that part of the record, and the parties are given a full opportunity to engage each other on the contents of that confidential affidavit. It's just that those exchanges of affidavits are subject to a confidentiality regime. And we don't ask for anything more than that. And in fact, we ask the Commission, if such an in-camera regime is going to be upheld in these circumstances, that that's the kind of consideration that is applied. May I say then, on the third topic that I had, which was about the cases that I wanted to deal with, I think these are fairly trite propositions that I'm making from the cases that I've cited. I've given my learned friend notice of those cases and the paragraphs that I'm going to rely on. So I'm not going to ambush her very deliberately. But my learned friend raises her eyebrows at me. These cases, we say, put forward two propositions. The one proposition is that the state has a positive duty towards citizens to protect them where there is a concern about their rights. That is derived from cases like Carmichael, Carmichael, I apologize, I always say Carmichael, Carmichael, at paragraphs 44 and 45, and the court will be familiar with Carmichael. And then the other case that we rely upon is the SCA case of Van Devenboden, which the commissioners will also be familiar with, and the paragraphs there are 20, 21, and 22. Now, why that's relevant, of course, is because we say that on the facts of this case, there is a threat to the right to life, security, integrity, family, commercial interests of the witness. This is a body that exercises public power in the name of the state, and so this commission is caught by the same obligations that the state has to make sure that where issues of safety are raised, that it properly applies its mind and discharges its power in accordance with that. The other two cases, sorry, I said 4 cases, there's 6 in total, and I'll come to the other 2 shortly. The other 2 cases that I want to refer to is the Constitutional Court matter of independent newspapers, otherwise I think commonly referred to as Masetla, at least that's how I know it. And the paragraphs there, the relevant paragraphs there are 42, 43, 44, 45, 58, 59, 60, and 61. And the other case that I would refer to whilst I'm talking about Masetla is the SABC versus NDPP case that came before the Con Court. And I think that was, I speak subject to correction, but I think that might have been in the context of Van Breda and whether or not his criminal trial could be subject to publication. And the paragraph we rely on there are 28, 29, 30, and 31. And what those cases make abundantly clear is that courts in those contexts, we say courts, it applies as equally as against this inquiry as a tribunal, must engage in a balancing exercise where default positions of openness, which is what the default rules of this commission envisage, conflict with competing and contesting rights. And where those competing and contesting rights are put before the court, and this relates to what I was saying earlier about one factor in the basket of factors, the court will seriously apply its mind to circumstances where it treats openness by default not as an absolute principle, that there are justifiable circumstances where it will derogate from openness as the default principle, and that those require then the application of this balancing act. And we say that some of those factors that need to be included in the balancing act are those cases, are the instances where my client comes to the commission and under oath tells you about the threats that he's facing to life, limb, property, and family. The other 2 cases, if I may, whilst I'm machining through this list, is MIDI Television. I apologize. I think MIDI Television was Van Breda. I said SABC versus NDPP was about Van Breda. But MIDI Television, which the tribunal will be familiar with at paragraphs 19, 20, and 21, and the other older constitutional court case of Mamabolo, which, if I'm not mistaken, was written by Justice Crickler, and the relevant paragraphs that we rely on there are 41, 42, and 43. And what we say those 2 cases give rise to